Hey there. Today we're talking about something that I get asked about all the time, and that is fair use, particularly how fair use applies to using copyrighted material in spaces such as YouTube. And to do that, I'm going to break down briefly, kind of, the H3 or Ethan and Hila Klein Matt Haas lawsuit that covered their commentary on a clip of a Matt Haas video, and the court ultimately ruled it was fair use and really broke down how the court evaluated what the fair use factors are and how the facts in this case applied. And hopefully it will help you determine how courts look at fair use and where the boundaries are for content you may be using, but as always, not legal advice. So let's just get into it and talk fair use here on YouTube. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. Before we get into the rest of it, let's take a moment to thank today's sponsor. I have changed the lights to reflect our sponsor today, and I am so happy to share with you a sponsored video from NordVPN. You're like, Emily, what's a VPN? A VPN is a virtual private network. It lets you browse the internet more privately and more securely. The way it does that is by encrypting your data and routing it through a remote server. And you can do this on a desktop, on an iPad, on your phone. You can route through over 61 different countries or through the US. Nord will work on up to 6 different devices with your subscription. I know, the whole family. All of the device, or maybe just yours if you're a tech nerd like me and you have all the things. You got the laptop, and the computer, and the iPhone, maybe a tablet, but you can use it on up to 6 devices with your subscription. Nord also has easy plugins for Google Chrome to protect your browsing, which I find very easy to use and use on my computer that I work from all day long. I also like that Nord has super fast servers and lots of bandwidth. Really important if you need to get work done and you don't want to slow down your internet with your VPN. And not all VPNs will let you know how fast their servers are, but Nord's are super quick. NordVPN doesn't keep any logs and they double encrypt your data, which is ideal for protecting your data online. And it can help cut down on those creepy ads that seem to know what you're thinking before you're even thinking it, that track you across the web. All you need to do to check out NordVPN is use the link here on the screen or click the link down in the description box. Use the code Emily D. Baker and you can get a 2-year plan at a huge discount and 1 month free of NordVPN. They're easy to work with, easy to install, and it's what I use to browse the web securely. So I hope you check it out. And if you do, let me know down in the comments. So excited to be working with NordVPN again this month. Let's get back into fair use. Let's talk a little bit about the procedural posture of the case, or as I often call it, the road so far. The procedural posture of this case is that the Matt Haas video called Bold Guy versus Parkour Girl was uploaded to YouTube on August 11th, 2013. And then on February 15th, 2016, Ethan and Hila did a reacts video. Their video is still up on YouTube, or re-uploaded on YouTube, I should say. And that video and the original Bold Guy versus Parkour video are linked down below, including the content creators' videos talking about this lawsuit because they do come up. This lawsuit was then filed on 4/26/2016 and ultimately dismissed by the court on August 23rd, 2017. So a year and 4 months of a lawsuit. As Ethan Klein has said in videos and other comment on this case, hundreds of thousands of dollars spent to get to this result, and it was dismissed after a motion for summary judgment. That is initial pleadings. It didn't go to a jury trial. The court decided it as a matter of law because the facts in this case weren't in dispute. Fact being, Matt Haas uploaded a video. Fact being, Ethan and Hila Klein also uploaded a video reacting or commenting on Matt Haas's video. And that's where this case finds us. Before we get to the court's ruling, I'm just going to give you a little bit of the background from the first complaint. There was an amended complaint after this alleging defamation based on a video that Ethan and Hila uploaded about the fact that they were being sued. So they got sued. They filmed a video called We're Being Sued. Again, it'll be linked down below. And then got sued for defamation based on their statements in the video about being sued. Before all of that, let's get into the original complaint, just so you can see essentially what Matt Haas was originally arguing before Ethan and Hila Klein filed a motion for summary judgment. So let's pull up the complaint. This is the complaint filed by Matt Haas against Ethan and Hila Klein, stating that Matt Haas lives in California. He's a recognized filmmaker. He has a loyal and wide cult following. Side note, Emily addendum sitting here in 2021, it seemed that after this lawsuit, Matt Haas stopped uploading YouTube videos, which is very interesting to me. I don't know if it was because of this. There doesn't seem to be like a goodbye video on the channel, or I'm through with this. I have no idea what happened to Matt Haas after this lawsuit, but there aren't more videos on that YouTube channel. Maybe there's a new channel. I don't know. Interesting note. He publishes original film and music productions on the popular YouTube. He files them on the YouTubes under a channel named the Matt Haas Zone. On Information and Belief, Ethan and Hila are individuals residing in New York and have a YouTube channel named Ethan and Hila. It talks about jurisdiction and venue. They went and filed this in New York where Ethan and Hila resided, so there was no issues with that. And then they get into the plaintiff's work. The plaintiff is the sole owner of the copyright and all other rights in the creative motion picture collection works titled The Bold Guy and Horny Tony Volume 1. Now, if that isn't the most 2013 thing you've ever heard, it is. And this includes the work Bold Guy 12 Parkour Girl. There is an attached recognition that this is a registered copyrighted work, that he is a independent filmmaker struggling to achieve mainstream recognition. He invests virtually all of his personal income into his projects, as well as functioning in multiple roles. Life of a YouTuber as the writer, director, producer, cinematographer, actor, editor, and even stuntman for his projects. He has passionately invested his time and energy, and occasionally blood, literally blood. They will describe it. It is actually literally blood as described in this complaint. In fact, on August 14th, 2013, during the 6-week period filming the YouTube video, it's linked below, go watch it. 6 weeks to film it, which included a highly physical parkour action sequence. Mr. Haas was hospitalized with multiple fractures to his skull, a fractured elbow, a concussion, and facial nerve damage due to blunt force trauma when Haas suffered a fall onto concrete while training for the work's action sequence. Look, maybe not be your own stunt coordinator. Also, I don't know how it's relevant to copyright and fair use. Like, I don't know how you breaking your face is relevant to copyright infringement, but I'm here for the storytelling in this complaint nonetheless, because otherwise I wouldn't have known that Matt Haas broke his face making this particular video that he is suing over, or had sued over. Needless to say, he invested substantial time, effort, money, and quite literally literal blood, quite literally his physical well-being. Then it gets into defendants' infringements. What did Ethan and Hila do? On February 15th, 2016, defendants published a video on their YouTube channel that copied and displayed virtually all of Mr. Haas's original work. Wow, does this sound like the Triller lawsuit to you? Maybe it does, but there's a date. Never mind. There's an actual date of when a thing happened in this one. The infringing video features the defendants purporting to discuss the work. They don't purport to discuss it, they discuss it in what they believe to be a humorous manner. I love the subtle digs at the commentary. They're like, they believe it's humorous. Ooh, we believe it sucks. But in fact, reproduces virtually all of the work as nothing more than a prop in the defendant's comedy routine. Well, if it's a prop, I think what they're saying is it's not transformative, or they're trying to say it's not transformative. But if it's a prop in their comedy routine, then it's not the core of their video. So it is transformative. So I thought they were already kind of skirting that line of it being transformative here, but we'll get into the factors for fair use in a moment. The infringing video does nothing to alter the original work. The infringing video fails to contribute substantive commentary, criticism, or even parody of the work. And I say, then how is it a prop if they're just airing it? On information and belief, the infringing video was published by defendants in a transparent attempt to exploit the popularity of the original work, which currently has more than 10 million views on YouTube. As I was filming this video, it had over 11 million views on YouTube, and I wonder how many views it gained because of this lawsuit after that. I imagine it's not really coming up in recommendeds anymore because it's been so many years. The infringing video was even advertised by defendants by utilizing a still thumbnail image for the original work. Okay, it's in the thumbnail, hasn't worked yet in one of these cases. It's in the thumbnail. It's in the thumbnail. They're saying that the thumbnail was specifically tailored by the defendants to confuse viewers into thinking that if they clicked the hyperlink to the infringing video, they would go see the Parkour Girl video. On April 2nd, Haas emailed the Kleins and requested they immediately remove the infringing video. They were disinclined to acquiesce to that request. On April 2nd, 2016, Ethan Klein responded on behalf of the Kleins, informing them that they were refusing to acquiesce to their request, refusing to cease the infringement, claiming the fair use exemption, which does come up in the judge's ruling, directing Mr. Haas to go and, to contact their attorney, daring Mr. Haas to file a takedown request with YouTube under the DMCA, and stating that the Kleins would dispute such a takedown notice, which in fact happened. There was a DMCA takedown notice. The DMCA takedown notice was then reversed when the Kleins actually did dispute it. Apparently, Klein said that the infringing video would be reinstated within 2 weeks. It looks like it was reinstated in less time than that, and that they have dealt with this many times, and such allegations of infringement were evidently, quote, a matter of routine to them. Well, they react to clips. Sometimes people try to claim copyright infringement, and they were like, no, it's fair use. We know how this works. I like that they try to throw it in there as shade, and my comment to that was, but were they wrong, though, because they won this lawsuit? So no. Upon information and belief, the defendant's YouTube channel more than doubled its numbers of subscribers, due at least in part to the popularity generated by the infringing video. And I said, there's the rub. You're mad, bro. Like, mad that their channel grew talking about your video. That's just the most YouTube-y thing ever, isn't it? It's like, but you were talking about me. Yes. YouTubers often talk about other YouTubers. That is the way of commentary. Then it gets into Patreon, Kickstarter, the fact that this is a claim for copyright infringement. And that really is the sum and substance of it. As I said, after Kleins got sued, they uploaded a video saying, we're being sued. And then they added claims for defamation. After that happened, they went back and forth with depositions and then filed a substantive motion for summary judgment. A motion for summary judgment is a motion that tells the court, please rule on this case now on the law. We're not disputing the facts. Facts are Matt Haas uploaded this video and owns the copyright to it. Not disputed. Ethan and Hila Klein uploaded a video and said what the fuck they said. Not disputing it. The facts are the facts. So as a matter of law, can this even go forward to trial? So Ethan and Hila arguing this can't go forward because as a matter of law, we are right and the factual allegations are not in dispute. And so for that reason, they filed a motion for summary judgment, and the court's ruling was it was well written. It was well articulated. It cited the relevant case law and really broke down fair use in a fantastic way. Let's get into the court's ruling on this matter. This ruling, we are not going to go through page by page, but this is from August 23rd, 2017. This ruling is actually cited on the U.S. copyright website, and I will link that down below. That gives a great breakdown of this case and the way that this case did strengthen fair use for creators that do use copyrighted works. Again, fair use is a defense to copyright infringement. Fair use means you've used somebody else's copyrighted work, but It's cool because it's used in a proper way. And this is a push-pull between copyright and really First Amendment freedom of speech. So it's trying to not silence speech by allowing for critical commentary and news reporting and education, but also protecting copyright owners that their works are not just going to be re-uploaded and redistributed and other people will benefit off of those works in a way that's improper. So as the judge says, Judge Catherine Forrest, Judge Forrest, we stand. This is a great opinion and we love it. This action principally concerns whether critical commentary on a creative video posted on YouTube constitutes copyright infringement. That's exactly what it is. The Klein's criticism and commentary is interwoven with clips from the Haas video. The operative complaint alleges the defendants infringed plaintiff copyrights, made misrepresentations in a counter takedown notice in violation of the Digital Millennium Copyright Act, and defamed plaintiff. The defamation. Before the court are dueling motions for summary judgment. Both parties filed a motion saying, but Your Honor, this can't go to trial. I win as a matter of law. The key evidence in the record consists of the Klein and Haas videos themselves. So the court watched these YouTube videos. Any review of the Klein video leaves no doubt that it constitutes critical commentary of the Haas video. There is no doubt that the Klein video is decidedly not a market substitute for the Haas video. And we will talk about what a market substitute is as we move on. And you can apply this thought process to other cases that I talk about on this channel and other things you're seeing and to your own use on YouTube. This is one court's decision of how this breaks down. Yes, it changes based on jurisdiction, but not a ton. And fair use cases, again, are a defense, which means you get sued and then you have a right to defend yourself, which can still cost hundreds of thousands of dollars. So understand how fair use works if you are using clips and things from others' creative works, essentially. Further, it is clear that defendants' comments regarding the lawsuit are either non-actionable opinions or substantially true as a matter of law. So, oh, by the way, the defamation also doesn't fly. Goodbye. For these and the other reasons stated forth below, plaintiff's defamation claim fails. Defendant's motion for summary judgment is granted. That's Ethan and Hila's. And plaintiff's motion is denied. Background. We've already gone through the background. We've talked about the complaint. This summarizes the complaints and talks about what the background is. The court then says the Klein video opens with commentary and discussion between Ethan and Hila, followed by segments of the Haas video, which they play, stop, and continue to comment and criticize. Then there is a footnote. Sass. The Klein video is arguably part of a large genre of YouTube videos commonly known as reaction videos. Videos within this genre are very widely in terms of purpose, structure, and the extent to which they rely on potentially copyrighted material. Some reaction videos, like the Klein video, intersperse short segments of another's work with criticism and commentary, while others are more akin to a group viewing session without commentary. Accordingly, this court is not ruling here that all reaction videos constitute fair use. And the court is making it clear because group viewing session videos are going to be less likely fair use, where critical commentary is more likely fair use. The court goes on to say the Klein video, which is 14 minutes long, intersperses short segments of the Haas video with long segments of commentary, ultimately using 3 minutes and 15 seconds of the 5-minute, 24-second long Haas video. The length comes into the factors down below that we will break down. In addition, defendant's commentary refers to the Haas video as a quasi-pornographic and reminiscent of cringe tube, a genre of YouTube video known for cringe-worthy sexual content. As critical as it is, the Klein video is roughly equivalent to the kind of commentary or criticism of a creative work that might occur in a film studies class. So the judge has elevated the commentary and said, look, this is critical of the content. You're allowed to be critical of the content, and you're allowed to be super critical of the content. As critical as it is, the judge says, you can be critical. Critique is a valid part of fair use. The court then breaks down the road so far, quickly saying that on April 23rd, 2016, plaintiff submitted a DMCA takedown, that Klein then responded with a DMCA counter notification, which is essentially saying, yo, it's fair use. Don't take down the video, YouTube. On May 24th, 2016, defendants posted a new video on YouTube titled "We're Being Sued." It's linked below, which discussed this action and criticized plaintiff for filing it. So they did critical commentary of plaintiff for his video 3 years after the video was made, and then critical commentary of plaintiff for filing a lawsuit against them. Normally, I say don't comment on it, but then, plaintiff went ahead and turned around and sued them also for defamation, but that was also dismissed because the statements really were opinion-based and not defamatory. So there's that. But plaintiff, Matt Haas, was already salty. So criticizing the filing of the lawsuit is going to make somebody more salty. But at that point, you're already in it. So I understand the point. I always say, if you're in a lawsuit, shut the fuck up about it. But everybody, your mileage on that may vary, and everyone's attorneys and everyone's own temperament are different. So the court gets into the legal principles, including the principles of summary judgment, explaining that on a summary judgment motion, they are not deciding the facts of the case. They are not here to say, well, is this, or is that, but there's no facts really materially at dispute here. The videos stand on their own. They say what the fuck they say. But if there are factual disputes, it weighs in the favor of the party who's not filing the motion for summary judgment. So it's assuming everything in the favor of the other party, all the stuff to them. Can they go forward and win this? And is there a substantial likelihood that they can win this? And that's what the court breaks down for the parties, and then gets into a great explanation of fair use. So this is the court's breakdown of fair use. Fair use is an affirmative defense to copyright infringement. It is a judicially created doctrine. That means the judges made this, and was first explicitly recognized in statute in the Copyright Act of 1976. The use of a work in any particular case is fair use, but courts must consider non-exhaustive factors, and they must balance and determine these factors. One, these are the four factors. The purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, the effect of the use upon the potential market for or value of the copyrighted work. And we see this really being leaned on in the Triller lawsuit. It's like, well, if you've aired the fight, then what is left for people to buy? And if you want to see those breakdowns of those lawsuits, they'll be listed. No single factor is determinative in this open-ended and context-sensitive inquiry. That means this goes jurisdiction by jurisdiction, court by court. The judges determine what these four factors mean, and they are guided by the judges that have come before them and cases like this one that came before them. But the burden is on the person using the copyrighted clips to prove to a court that they have met these four factors. So understanding how the courts evaluate them, I find to be very helpful. The task of determining fair use is not to be simplified with bright line rules. There's no cut and dry here. For the statute calls for case-by-case analysis. Every situation is different. And in this situation, they break down what the different factors are and how much weight they have. Although no factor is independently determinative, the heart of fair use is the first factor, whether the use is, quote, transformative by, quote, adding something new with a further purpose or different character. The court goes on to say the central purpose of this investigation is to see whether the new work merely supersedes the objects of the original creation, or instead adds something new with a further purpose or different character, altering the first with new expression, meaning, or message. The court went on that among the best recognized justifications for copying from another's work is to provide comment on it or criticism of it. That there is a strong presumption that factor one favors the defendant if the allegedly infringing work fits the description of uses described in section 107, including criticism and commentary. And then it goes on to say that in the preamble in section 107, criticism, comment, news reporting, teaching, scholarship, and research might be deemed the most appropriate for purpose or character finding indicative of fair use. Comment and criticism. That's a lot of what creators do on YouTube, and a lot of it's covered under fair use. The court then goes on to find, and I just thought this was sassy and fabulous, there's a court case over Three's Company, and the court found that the play 3C makes fair use of the television series Three's Company, in part because the play criticizes and comments upon Three's Company by reimagining a familiar setting in a darker, exceedingly vulgar manner, which makes me want to go find this play because now I am kind of obsessed with what the darker, exceedingly vulgar version of Three's Company is. Though I can kind of imagine for myself, I want to know. And I'm fascinated that this is a case that was decided in 2015 in the courts in New York. We might have to do a deep dive. The second factor, which is rarely found to be determinative. Determinative means like this is the most important factor, and these are lesser important factors. And that calls for recognition that some works are closer to the core of the intended copyright protection than others, and it's the nature of the artistic creation. The third factor is a consideration of the amount, or I hate pronouncing this word, the substantiality of the portion of the copyright work used in relation to the copyrighted work as a whole. I get asked quite a lot, how long can a clip be? And I think creators want hey, you can use a 15-second clip. That's not a bright line rule. There's no rule of thumb here because it depends how much of the work it is, how important it is to the work, and if it alters or changes the work, it all goes together. But what we saw here is the court being very clear that the stopping and starting and the commentary over the clip was a factor that was heavily considered. This factor requires courts to consider not only the quantity of the materials used, but also their quality and importance. How critical was the part that was used? And then the fourth factor focuses on whether the secondary use usurps demand for the protected work by serving as a market substitute. Meaning, can you substitute the original work for the secondary work? And then the court weighs those factors in context of this case. The court also breaks down market substitute a little bit more, which I think is helpful. Talking about whether an infringing work serves as a market substitute for the infringed work is not merely whether the market for the infringed work was harmed, which I thought was very interesting. The court points out a case that said a lethal parody, like a scathing theater review, kills demand for the original, but does not produce a harm cognizable under the Copyright Act. So your critical commentary could be like, like a scathing book review that uses excerpts of the book, or a scathing movie review that uses excerpts of the movie. And then people are like, oh, well, that sounds like shit. I don't want to go see it. That is not what the damage is under copyright, because that's actually the point sometimes of critical commentary. But what it is asking, could somebody essentially see the entire movie through your video, see the entire or read the entire book, and then they don't need to seek out the original because it's essentially a dupe for it. And if that's not the case, then this factor is not as likely to be found. The court goes on to say that the role of the courts is to distinguish between biting criticism that merely suppresses demand and copyright infringement which usurps it, meaning substitutes the demand for it. And I thought that that was a really clear and concise definition from that Campbell opinion. The court then goes on to talk about the DCMA misrepresentation and finds that in this case, the DCMA misrepresentation or claims of misrepresentation were not found here. And it was found that the Kleins had a good faith belief that this was fair use, and the fact that they won kind of bolsters that. They just talk about whether someone knowingly materially misrepresents that they believe that it was a violation or not. What I love is that the court wrote about the takedown notice and said a copyright holder is not liable for misrepresentation under the DMCA if they subjectively believe that the identified material infringes on their copyright, even if that belief is ultimately mistaken. But it has to be actually a belief, not use for an improper belief or harassment. It has to be a good faith belief that you're trying to take something down because you think it infringes. But you also need to be able to look at something and say, oh, could this be fair use, even if I don't like the criticism or critique of the thing? In defamation, the court said, because falsity is an element of defamation under New York law, truth is an absolute defense to a defamation claim. We talk about this a lot. Isn't there always a little bit of defamation like sprinkled into all the YouTube cases we talk about? Just a little bit, just defamation, just sprinkled here and there. And the court went on to say it is well established that a statement need not be completely true, but can be substantially true. And we saw this in cases like the Johnny Depp case out of the UK. And then the court goes on to say, as when the overall gist or substance of the challenge statement is true. The common law overlooks minor inaccuracies and concentrates on substantial truth. The court goes on to say, along similar lines, statements of pure opinion as opposed to statements of fact are not actionable as defamation under New York state law. But that said, however, this is an important distinction because people are like, it's my opinion. It's my opinion. Don't be out here like it's my opinion, because here's the thing. When an opinion, quote, implies a basis in undisclosed facts or facts known only to the author, it may be actionable as a mixed opinion. Meaning, yeah, it's an opinion, but you are implying that it's based on like, but I know, like I've got the scoop. Like if you had seen what I had seen, if you knew what I knew, but I've heard behind the scenes, this kind of, I have this deeper knowledge and my opinion's based on information. Well, then that's kind of stating a fact. It's stating that your opinion's based on a fact, and that fact, that underlying fact may be defamatory. I thought it was very interesting the way the court broke this down. And very helpful the way the court broke it down. And then the court gets into the discussion, the copyright infringement being the most important for our purposes. For the first factor and the most important, the court found that it weighs heavily in the defendant's favor. As discussed above, criticism and comment are classic examples of fair use. The Klein video is quintessential criticism and comment. Illustrative examples include, and the court goes in and breaks down some of the things said. And I love it. The court says that Klein remarked that Bold Guy comes from an older day of YouTube and refers to plaintiff as the king of cringe tube. And then they mimic the movement of the words by performing a dance in his seat. And the court just goes on and on about the different examples of criticism. Defendants sarcastically compliment the, quote, sleeveless hoodie that Bold Guy wears, calling it, quote, one of the classiest pieces of clothing you can own, end quote. And the court made a note that although the Klein video is not timestamped, these are illustrative examples in chronological order. So they go through the different statements made about the video. The court goes on to compare this to the cases that were mentioned earlier and said that the first factor weighs in defendant's favor. I mean, clearly the court stated at the beginning that the defendants had won, but the court is showing both sides and everyone else how they came to this decision and how they determined which factors weighed for which party. The second factor examines the nature of the alleged infringing work. Defendants, the Kleins, argue that Haas's video and plaintiff's Bold Guy video skits are factual rather than creative because the plaintiff has said he draws inspiration from the character from his own experiences and personality. The court disagrees, and the court goes on to talk about the fact that fictional works can be based in reality and inspired from reality, but that doesn't change them from being like fictional creative works. So this is a creative work, and because the court determined it to be a creative work, the second factor weighed against finding fair use because creative works are what is protected by copyright. The court goes on to the third factor and examines the amount and substantiality of the portion of the copyrighted work used. Defendants argue that the third factor weighs in their favor because plaintiff's video constitutes only a small portion of the content of defendant's video. They say that the defendants, the Kleins, get the math backwards, and that the third factor considers what portion of the copyrighted work the infringed work uses. And this is what I've said in my coverage of things like the Triller lawsuit. It's the amount of the other work, not your own work, but for how much of the copyrighted work you're using, they look at how much of the copyright work has been used. Now, things like damages can go into how long your underlying work is, but for the substantiality, it's how much of, are you using 90%, 100%, 5%? How much of that other work did you use? So the court talks about it's the copyrighted work that matters, and then how well tailored that use was to the alleged infringer's work and proper purpose, no matter how large or long the alleged infringing work is. They say that defendants, the Kleins, use a number of short segments of plaintiff's work, interspersing their commentary and critique along the way. It is certainly true that when one adds up all the segments used, it totals to 3 minutes and 15 seconds of a 5-minute and 24-second video. The law is clear, however, that quantity alone is not determinative. So how much you use is not the thing. It's evident that the comment on and critique a work, clips of the original may be used. And then the court goes on to say, without using actual clips, the commentary and critique would lose context and utility. So the extent and quality and importance of the video clips used by defendants were reasonable to accomplish the transformative purpose of critical commentary. This factor is therefore neutral. A great deal of plaintiff's work was copied. So that part goes to plaintiff. You used a substantial portion of the work, but such copying was plainly necessary to the commentary and critique. So it is a wash essentially on this. And then the court gets into the fourth factor, the commercial impact of the infringing work. And this weighs in favor of defendants. The purpose of the fourth factor is to determine what degree an alleged infringing work usurps or takes up the demand for the copyrighted work, thereby resulting in a loss. And the court goes in and says it is clear that the Klein video does not serve as a market substitute for the Haas video, because anyone who wants to enjoy Bold Guy versus Parkour Girl on its own will have a very different experience watching the Klein video. You can't just sit down and watch Bold Guy and Parkour Girl, get the story and get the feel for that video, because what you're going to get in the Klein video is Ethan and Hila ripping on the video, because that is the purpose of their video. So it is not a market substitute and doesn't usurp the market for it. So the fourth factor weighs in favor of fair use. The court goes on and denies the DMCA misrepresentation claim and goes on and denies the defamation claim. There's a sassy footnote that we're going to talk about just for a second, because I love a sassy footnote. So under the DMCA misrepresentation, the court dismisses the claim and then says, in its order dated January 18th, 2017, the court characterized claim 2 as exceptionally weak. Plaintiff has done nothing to strengthen his claim in the time since that order was issued. This is the court taking just a moment to remind Matt Haas's counsel and plaintiff as a whole that I thought that this was weak. I told you that this was weak and you gave me nothing, and I am dismissing it. So goodbye for that claim. The court then goes on and breaks down why the court is getting rid of the defamation. Just for a moment, the plaintiff argued that the defamation was based on Ethan and Hila sitting down in a video saying they were being sued by Matt Haas, and said, I think that the heart and soul of this is he doesn't like that we made fun of him, and so he's suing us. They say this is quintessential statement of opinion. It's not defamatory. You're saying you didn't like us making fun of you, so now you're suing us. And the court went on to say that these defamation causes of action are terrible, and they're dismissing them. And they really aren't defamatory. They just aren't. And the court goes on and breaks that down, and which is why the court dismisses that at all. The court has some fabulous sass in breaking down the defamation costs here and throwing out the defamation cause of action. But we're here today to talk about fair use. At the end of this, the court says, for the foregoing reason, defendant's motion for summary judgment is granted in its entirety. What that means is that the entire underlying lawsuit is thrown out. All the causes of action are thrown out. The motion for summary judgment's granted, and that's with prejudice. So the Kleins couldn't be sued again, and ultimately they weren't. I hope that breaking down those 4 factors of fair use helped you understand better how courts look at and evaluate those 4 factors and what types of things that they weigh when you are using copyrighted works for comment, criticism, education. Understanding the ins and outs of how the court look at it is important, and doing that evaluation when you're creating content on your own is helpful. So if you have questions about fair use, make sure that you review it for yourself. If you really have questions about a piece of content, run it by a local attorney, talk to them about fair use so you can get a good breakdown on your type of content and how your type of content might use copyrighted works, because the ins and outs of using somebody's YouTube video versus using a big studio movie versus using music are all different. Using music in the background of your YouTube generally is not fair use. And just because it's fair use doesn't mean it can be monetized on YouTube, doesn't mean that YouTube will necessarily allow it to be up without a copyright claim that you then have to defend. It's a defense to using someone else's copyrighted work. Let me know if you have questions down below. Let me know if this video was helpful. And don't forget to do the YouTube-y things. Like, subscribe, give a thumbs up, and I will see you all around the interwebs. Thanks for being a law nerd. See you soon. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube